So hi everyone, this is CA Akshay Nagpal and we are here to discuss about section number 186 today, which talks about loan and investment by company. And in this section, there are basically two bifurcations. First bifurcation is about 186 subsection 1, which talks about the permitted investments. And the second bifurcation is about 186 subsection 2 to 186 subsection 14, which talks about the procedural part. That is, a company has to follow some procedures in order to give loans, give guarantees or securities, or provide investments. So they have to follow some procedures in order to conduct that course of action. And as soon as they comply with all the things, then they are good to go. Or if they do not, then a penalty section is given in section number 186 as well. And it also talks about basically few things. Plus one more thing, it's 186 subsection 11 talks about is the non-applicability of the section, except for 186 subsection 1, which basically tells us that the few companies, that is insurance company, banking company, can in ordinary course of business provide loans and investments without conducting any procedural part that is given in section number 186. And that is the brief of this section. Plus we are going to do this in very much detail, and you'll be able to realize that now your understanding is more better than the earlier ones. All right, so let's discuss section number 186 subsection 1 first, which is the first part of this section. And here we are going to do it in very much detail, but it will be very easier for you from now on, that I can make sure. All right, so let's discuss about section number 186 subsection 1. First of all, let's discuss the applicability of this section. 186 section is applicable for both public and private companies. Remember that public and private companies, both companies shall have to comply with section number 186. And it basically tells us that there are three rules: rule number 11, rule number 12, and rule number 13. It talks about the provisions which govern the making of loans and investments, guarantees, and providing of securities. All right, so these three rules plus section number 186 we are going to discuss today. Three rules plus section number 186. All right, let's first discuss about investments permitted through two layers of investment companies. So it talks about layers. Layers, what do you mean by layers? You can simply call it as a subsidiary company. For example, A is a holding company. Then it invests in a company B, which is a subsidiary company. This is its layer. And B investing in C, which is again its subsidiary company. It is its second layer. So it tells us about these things. Let's read it first. A company, unless otherwise prescribed, is not permitted to make investment through more than two layers of investment companies. What does it tell us? That a company, that is here in our case, a company A can invest in two layers easily. This is first layer and this is second layer. A company can invest in not more than two layers. For example, if C wants to invest in company B, which is its subsidiary, so it cannot invest in subsidiary D, since this will make the third layer. Hence, a company, that is holding company, can invest only in these two companies, B and C. This is called layers. All right, let me clear one thing for you. Let's take a new page first. It talks about vertical layer. Remember that. It is not talking about horizontal layer. Let me give you an example first. Vertical layer, here it means A, B, C, D. All right. This is holding company. This is subsidiary of A company. This is first layer. C is subsidiary of B company. That is second layer. And D is subsidiary of C Limited. This is third layer. So a company can go up till C. This can be the only outcome of this provision. All right. So the third layer, that is D, cannot be the subsidiary of C, since C is prohibited to invest in a company D. All right. This is what this section is all about. Now coming to horizontal layer, that is if a company is A and it invests in B, it invests directly in C, it invests directly in D, and it invests directly in E. All are its subsidiary company. Subsidiary, 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 subsidiary. So these are all only and only first layer. Remember that. So this is very much accepted. This is not prohibition of section number 186 subsection 1. All right, remember that. यहाँ पे बच्चे confuse हो जाते हैं. Let me tell you one more thing in regard to section number 186 subsection 1, that it has given two exceptions for this rule. That is, the first rule, if it is a wholly owned subsidiary, then you should not count it as layer. It is not considered as layer. All right. And if a company invests in a company incorporated outside India, then again it is not considered as layer. It will be governed by the laws outside India, the country in which the company is incorporated. All right. For example, A Limited, that is a holding company, wants to invest in B Limited. B Limited wants to invest in C Limited, and C Limited wants to invest in D Limited. All are the subsidiary of each other. And if, for example, B is company incorporated outside India, and this is, for example, Singapore. If the company is if B Limited is incorporated in Singapore, and the Singapore country allows its companies to invest in more than 2 layers, then it can very well do so. All right. So there will not be any prohibitions. They can invest in any company in whatsoever combination available. All right. So this was about that. Now let's read the section first, and then we will come back to the examples. All right. So yes, placing of such restrictions helps in preventing diversion of funds. The reason is given for section number 186 subsection 1, to prevent diversion of funds. What was earlier being done is, basically A company used to make many subsidiaries of itself. A company, B makes a subsidiary C, C makes a subsidiary D, D makes a subsidiary E, and E makes a subsidiary F. Then F used to do something illegal. Then in order to find the real culprit, it was very difficult for the registrar or the investigators to find the real culprit. So they had to implement a section which prohibits the layering part. That is A, B, and C. This is the maximum combination that can be done simply. All right. The maximum number of investments that can be done is up till C only. All right. That is why this section was introduced. I hope you understood. All right. So now let's discuss about other things. It simply says that It is clarified by way of clause A of explanation that the expression investment company का meaning दे रखा है यहाँ पे, which we will discuss later on. All right, now let's discuss about the exceptions to the rule of two layers that we have already discussed, but let's read it. In the following cases, the provision of section number 186 shall not apply. That is, rule of two layers shall not be applicable if a company is acquired and the company is incorporated outside India. That is, if a company acquires any other company incorporated in a company outside India, and if such other company has investment subsidiaries beyond two layers as per the laws of such country. हमने सिंगापुर का example लिया था अभी. This is the same thing that we have discussed, right? The rule of two layers shall not prevent this kind of acquisition. So a company can very well invest in a company incorporated in Singapore or any other country for that matter, if and only if that other country allows the companies to invest in more than two layers of investment. All right, and the second part is about a subsidiary from having an investment subsidiary. Again, the rule of two layers shall not prevent a subsidiary company from having any investment subsidiary for the purposes of meeting the requirements under any law or under any rule or regulation framed under any law for the time being in force. This section cannot be practically implied anywhere since किसी भी rules या फिर किसी भी law या फिर किसी भी regulation में it is not simply said that the subsidiary company can have an investment subsidiary can have more than two layers of investment subsidiaries. So this cannot be practically implemented, but you will have to remember that anyway. And one more thing that I have told you about the wholly owned subsidiaries, that these wholly owned subsidiaries are not called as layers. This is discussed in rules. All right, this is not covered in section number 186, but you will have to remember it anyway, since the question can be asked for that as well. Now let's discuss about a few illustrations. There you will have a better understanding of that. All right, now let me summarize it for you first. All right, for example, A Limited, which is a holding company, is investing in B, that is its subsidiary company, and B is again investing in other subsidiary C. This is the maximum that they can go. Now talking about the exceptions part. Exception number 1. A Limited, which is again the holding company, is investing in B Limited, which is its subsidiary company, and B Limited is investing in C Incorporation, which is company incorporated outside India. This is its first layer. B Limited is its first layer, and this company which is incorporated outside India is not second layer, since this is in the exception part. And if the country in which it is incorporated allows to make investment in more than two layers, then they can easily invest in n number of companies. And there will be no violation of section number 186 for that matter. All right, now talking about exception number 2, which is about wholly owned subsidiaries. For example, a company is A Limited and its investment in B Limited, which is its 100% investment, that is wholly owned subsidiary. All right, this will not be called as layer. All right, and then B Limited invests in C Limited, which is 51% subsidiary. This will be its first layer, and C Limited invests in D Limited, which will be its second layer, 51% subsidiary. So it will be very much allowed till D Limited. All right. Now let's head to section number 186 subsection 2 to 186 subsection 14, which basically talks about the second part of this section, which is quite important, and you can expect at least 6 to 8 marks question from this section as well. So be more careful with this part of your section. All right. So in simplicity, it talks about loans, guarantees, securities, and investment. Loans, guarantees, and securities are indirect loans, and investments. 2, body corporate. Remember, body corporate also includes foreign companies. And the corporates which are basically established because of other acts, because of other statutory acts. For example, a banking company. A banking company is established because of RBI Act or Banking Companies Act. So that is also known as body corporate. So if a company wants to give loan, provide security, or give guarantee, or basically invest in any body corporate, then they will have to comply with section number 186 subsection 2 to 186 subsection 10 or 14. We will see about that. All right. So we will discuss it thoroughly. Then we will make a flow chart which will help you in basic understanding, and we will also create a summary that will help you for a one-day revision before exams. All right, so let's get into it. All right, so according to section number 186 subsection 2, following types of transactions, both direct and indirect, shall be subject to specified limit as depicted in the diagram. Giving of loans to any person or other body corporate, giving of guarantee or providing of security in connection with the loan to any other body corporate or person, again, and acquiring by way of subscription, purchase, or otherwise, that is investment. Investing in the securities of any other body corporate. So again, loan, guarantees and securities and investments in body corporate and other person. Person includes any person but excluding the employees. वो यहाँ पे given होगा that the person does not include any individual who is in employment of the company. But again, there is a catch here. MD and WTD are excluded from employee. Inference being MD and WTD 186 applicable, other employees 186 not applicable. Okay, so you can see it here as well. The MCA has clarified that the loans, advances made by the companies to their employees are not governed by the requirements of section 186, but other than managing director or whole-time director. All right, this is very, very important. This is just clarification. All right, so let's see it through a chart here. No company shall give any loan, give any guarantee, provide any security, or acquire by way of subscription, that is investment, exceeding 60%. This is a limit which we will discuss. Wait for a few minutes. In other words, this is nothing, just ignore that for the time being. Here it is given that prior approval of special resolution for exceeding limit. Again, wait for few minutes. Special resolution की बात कर रखी है, again wait. Note 1, in case of again wait. So yes, now we will make a particular chart in which you will be able to understand it very nicely. All right, so basically guys, section number 186 subsection 2 to 186 subsection 14. So it says that first, loan, guarantee, security and investment to any body corporate or any person other than employees. And employees may be MD, WTD excluded. That is any person plus MD and WTD. All right. So if a company wants to provide loans, guarantees and securities and investment to body corporate or any person, including MD and WTD, but excluding other employees, then they will have to comply with few conditions. First, they will have to pass a unanimous resolution. We will discuss what unanimous resolution is. Second, we will have to see a particular limit. If limit is exceeded, then special resolution is passed. Third, PFI approval. PFI is Public Financial Institution. This is taken in two cases, first case and second case. First case is if limit is increased, limit is exceeded, same as above, or second, there is any default in repayment of principal or interest. All right, and the fourth point is about deposits. It says that if there are public deposits and we have defaulted, then unless otherwise we have made that default good, we cannot provide loan, guarantee, security or investment. All right, so this is what the summary is all about, and again there are more points then that we will be discussing later on. All right, so let's head to the notes right now. Yeah, so prior approval by a special resolution if limit is exceeded. हमने अभी लिमिट देखी नहीं, लिमिट क्या होती है, where the aggregate of the loans and investments so far made, the existing loans, the amount for which guarantee or security so far provided, or in all other body corporates along with the investments, loans, guarantees or securities proposed. So existing loans plus proposed loans. Loans here means loans, investments, guarantees and securities. All right. So if this exceeds the limit, then no investment or loan shall be made or guarantee shall be provided unless previously authorized by a special resolution. So special resolution will be required. Now let's understand what the limit is. Limit is basically 60% of paid up share capital plus free reserves plus security premium, or 100% of free reserve plus security premium, whichever is more, whichever is higher. If this limit is surpassed or exceeded, then we will have to pass a special resolution. This is we have read. Special resolution means members 3/4 of the power, more than 3/4 of the power shall have to approve the loan, guarantee, security and investment. All right. So this is all about that, and these are the two notes. In case of provision of section number 110 of the Act apply to the company which is considering giving of loans or extending guarantees in excess of the limit, it shall pass the special resolution. It basically says that postal ballot se bhi kar sakte hain. And a one-person company and other companies having members up to 200 are not required to transact any business through. So postal ballot is not required in case of other person company or one-person company, or where the company has not more than 200 members. So it was about postal ballot basically. When is postal ballot required? All right. So now there is a rule number 13 which talks about the disclosure of total amount in resolution. So it just says that if a special resolution is passed, then special resolution should contain the amount up to which a loan, guarantee, security, or investment can be made. So amount needs to be mentioned, disclosed. All right. So let's read it. A resolution passed at a general meeting in terms of section number 186 subsection 3 to give any loan, guarantee, security, and investment or the acquisition under section number 186 subsection 2 shall specify the total amount up to which the board of directors are authorized to give such loans or guarantees. All right. So now next exemption we will study. Exemption from special resolution where a loan or guarantee or security is given to wholly owned subsidiary or a joint venture company, or acquisition is made by holding company by way of subscription, purchase, or otherwise of its wholly owned subsidiary. So it simply says if a holding company is providing loan to wholly owned subsidiary, then special resolution need is not required. All right. Just remember this. And there is one disclosure requirement in the financial statement. In case of exemption from special resolution, the company shall disclose the details of such loans or guarantees or securities or acquisition that is provided under section number 186 subsection 4. So if special resolution is not passed, for example, in case of this holding company giving loans to wholly owned subsidiary, then in financials a disclosure is required to be passed. All right, this disclosure is required to be made. Now let's understand next subsection 186 subsection 4. The company shall make full disclosures to the members as depicted in the following diagram. So it's just a format that is given in section number 186 subsection 4 plus rule number 13. All right, company shall disclose to the members in the financial statement. Financial statement क्या होता है? Balance sheet, P&L, and notes to accounts and cash flow statement. So they will have to show in the notes to accounts that the loans given, investments made, and the purpose shall also be needed to be provided. Now let's talk about unanimous resolution, which is very much important for your exam purpose. Now let's discuss about unanimous resolution first. So unanimous resolution is a concept in itself. It is applicable in two sections, section number 186 and section number 203. Only these two sections requires the resolution to be unanimous. All right. So first requirement here is, let's discuss it in detail. And there are two requirements. You can simply divide it into two. If 1 plus 2 happens, then we can simply say that it is unanimous. All right. First is presence of quorum. Directors are present. Quorum is there. All right. And all directors who are present are in favor. That means that even if one director is abstaining from voting, or even if one director is not in favor, then unanimous resolution is not there. All right, so only and only quorum should be there, and all the directors that are present should be in favor of the resolution that is being passed. Let's take few examples, then we will see whether the unanimous resolution is passed or not. All right, example 1. Directors are present in quorum. There are 5 directors which are present. All right, so 1A case, 1B case, and 1C case. 4 voted in favor plus 1 abstained. Here 4 voted in favor plus 1 voted against. 5 voted in favor. Quorum was 5 directors, and all the 5 directors are present. That is, quorum is made. First condition is passed, and 4 voted in favor. So, in order to have a unanimous resolution, all the 5 votes should be in favor. That is, here it is unanimous, and in all the other cases, that is, if a director is abstained from voting, then not unanimous. And similar is the case in 1B, 1 voted against. All right, so these 2 cases are not unanimous, and the third case, that is 5 voted in favor, it is a unanimous resolution. I hope I made myself clear. Now let's head to the other part. Unanimous resolution. Any investment shall be made, or loan, guarantee, security, and investment can be made if the resolution sanctioning it is passed at a meeting. Board meeting is necessary. Remember that. Board meeting of the with the consent of all the directors present at the meeting. That is unanimous resolution. All the directors present, jitne bhi directors hain which are present, are giving the consent. The prior approval of the public financial institution concerned where any term loan is subsisting shall also be obtained. PFI approval की बात भी करते हैं अभी. Circumstances when no prior approval for public financial institution is required. This is simply says that if within limit plus no default in repayment, then PFI approval is not required. And in the case that we read, we simply said that the PFI approval is required when limit is exceeded or default in repayment of principal and interest. So, in other words, PFI approval is not required when limit is not exceeded plus default is not there. All right, so this is what we have studied here. Circumstances when no prior approval is required, when it does not exceed the limit and there is no default in repayment of loan or payment of interest. All right, I hope you understand this section requirement. All right, so rate of interest, it talks about 186 of section 7 talks about the rate of interest part. It simply says that a loan under this section shall be given at a rate of 1 year, 3 year, 5 year, or 10 year government security closest to the tenure of loan. For example, a loan is being given for 10 years by the company to other body corporates or any other person except employees, but including MD and WD. So if the loan is given for 10 years, then the rate of interest should be matched with the government security loan which is of 10 years. All right, and this should be a tax-free bond. Remember that it can be asked in MCQ. All right, so yeah, there is a modification in section number 186 subsection 7 in respect of section 8 companies. It says that this is a anomaly, very difficult to be asked in a question, but you can not ignore that. All right, so yeah, another part is about no giving of loans etc. till default in respect of deposits is subsisting. If there is any default in deposits, then loan cannot be given. All right, a company which is in default in the repayment of any deposits accepted before or after the commencement of Companies Act 2013 or in payment of interest, the company shall not give any loan or guarantee or security or make an acquisition till the default is subsisting. First, you will have to make good the default. हमने यहाँ पे ये वाली बात भी पढ़ी थी. Deposits, if defaulted, then we cannot provide loans, guarantees, securities, and interest. All right. First, we will have to make good default. Then only we can pursue giving loans, guarantees, securities, or make an investment. Now it talks about maintenance of registers, which is basically says that every company giving loans or giving a guarantee or providing security and investments, they will have to comply with rule number 12, which says that form number MBP2. In form number MBP2, the register shall have to be maintained where it is written that loans, guarantees, and acquisitions that are being made shall have to be basically documented in form number MBP2. Let's read it in this chart. Every company shall, from the date of its incorporation, maintain a register in form MBP2 and enter the particulars of loans, guarantees, securities, and acquisitions made, and they will have to make it within 7 days of making such loans and guarantees and securities and investments, and the entries in the register shall have to be made chronologically. All right, so pehle FIFO basis basically, first in, first out. All right, and the maintenance of a register shall have to be kept at the registered office of the company and shall be preserved permanently. Remember that koi time limit nahi given, it is to be preserved permanently. And should be in the custody of company secretary or any other person authorized by the board. The entries in the register shall be authenticated by the company secretary or the company, and the extracts can be furnished at the rate of rupees not more than 10 rupees per page. All right, किसी member वगैरह को चाहिए हो, then they can have it for after paying some money which cannot exceed rupees 10 per page of that MBP2 form. All right, now let's talk about the non-applicability part, and let's cover this section as well. Here we are making a summary out of here that form MBP2 is required to be made. Here there are few things, that is within 7 days the same has to be filled and shall be preserved permanently. The third part was in a chronological order and authorized by CS or other authorized person. And the members will be charged maximum rupees 10 per page. All right, so now let's talk about the non-applicability of section number 186 except 186 subsection 1. 186 subsection 11, it basically says that banking company, insurance company, and housing finance company, if in ordinary course of business are doing their business and providing loans, investments, and guarantees, then this section is not applicable. And the second part is about company which is incorporated for this very purpose, to provide loan, investment, and guarantee and security. Then this 186 subsection 2 to 186 subsection 14 are not applicable. as per 186 subsection 11. But 186 subsection 1 is very much applicable. 186 subsection 1, which talks about the investments in layers, not more than 2 layers. All right, so वो वाला अलग section था. All right, now this thing we have already studied, made by a company established with the object of and engaged in the business of financing industrial enterprises or providing infrastructure facilities. Company for providing infrastructure facilities or for financing industrial enterprise, and other things being to any investment made by an investment company made in shares allotted to pursuance of section number 62, which is about right shares, and made in respect of investment by the NBFC. So it says that if investments are done by investment company, second, in pursuance of section number 62, that is right shares, and third by NBFC, then again 186 subsection 2 to 186 subsection 14 is not applicable for following companies. All right, now let's head to the other part. This is, you can ignore, this is not asked, this cannot be asked in your exams. Now let's talk about the punishment part. If 186 is contravened, then company will be punishable with the fine of rupees 25,000, which can go up to 5 lakh. Then minimum 25,000 to rupees 5 lakh. And second, every defaulting officer, that is, can be CEO, can be MD, can be WTD, can be other directors which are responsible for the same. Every defaulting officer for the imprisonment maximum up to 2 years, and plus with fine same 25,000, but maximum is 1 lakh rupees here. So simply 2 years imprisonment plus 25,000 rupees fine up to 1 lakh. All right, remember that. Now there are some exceptions that are given here, that section 186 is not applicable to a government company engaged in the defense production and a government company other than a listed company, in which in case such company obtains approval of the ministry or department of the central government, which is administratively in charge of the company. So they will have, if either the government company is engaged in the defense production, or the government company is not a listed company, plus they have taken the approval from ministry, then plus they have already complying section number 137 or section number 92, then the government company is not liable to basically comply with section number 160 to section number 186. All right, I hope I made myself clear. So the summary that we have made, let's complete that again. The sixth part was about the non-applicability part, which is given in section number 186 subsection 11, and the seventh part is about the penalty. I hope I made myself clear, and this section is done here, completed here. So if there is any doubt, then you can ask the doubt in the comment section, or you can have a WhatsApp chat with me. All right, so let's wrap it up here. So thank you so much, everyone. I'll see you in the next video. Thank you.